Hi, everyone, and thank you so much for joining us. It's lovely having you here. And I'm Refqah, and I am the Director and Head of Estates, Wills, Trusts, Curatorships. And we're based in the Claremont office. As you know by now, STBB has branch offices throughout the country. And on the screen behind me, you'll see my department email address, which is estates@stbb.co.za. And looking forward to hearing from you. And sit back, relax. We've got an hour. I'm going to chat for about 45 minutes. And then if there are any questions, we'll take those as well. And if there's anything that you're unsure about, or because we've only got an hour together, if I whip through anything too quickly, if you want to reach out, do email at estates@stbb.co.za. Throughout the talk, I'm also going to be mentioning a document called our life file. If you visit the STBB website, you'll get so many brochures and handy tips and flow charts as to the estate administration process, or estate planning and wills, and also trusts and curatorships. And there should be a link to the live file as well, but otherwise just pop us an email and we'll send you the live file, which is a handy document where you can record all of that information that you wish your loved ones had access to when you pass away, or if you're hospitalized and someone in the family needs to know, what's the details of the plumber or that gardener that mom always calls, or what's your SARS login details. You might not want people to know what your password is to your phone, but good to have that recorded as well. And it's funny how we'll just go through life and won't realize that our own family members might not know where we bank. They might not know that I exist in your life and that I drew up your will and that your will exists. And we can chat about that quite a bit. The importance of family knowing where your documentation is. So all of that you can record on the live file, and then you can save that, or you can share it with loved ones. You can save a hard copy. And it's also quite handy to fill that in and give that to us and or whoever's drafting your will, so that we can keep all of that information, your schedule of your policies and all of that. So that's what today is going to be about. I like to have practical chats, and people don't like speaking about death. They don't like facing their own death, thinking about their parents' death, their loved ones passing away. But death and taxes are inevitable. And so we're going to chat about some estate planning, and we won't have time to go into all the costs involved. But of course, being me, I'll touch on those and I'll rein myself back in and come back to what we're chatting about today, which, being Women's Month, we really wanted to take the opportunity to chat about the different stages of your life and what your different priorities might be, and how your assets and liabilities and taxes change over the stages of your life. And welcome men, if there are any men online. And so the majority of people online today I see are women. And so I'm going to chat to you as if you are a woman, guys, so don't take offense. And as I'm chatting to you today, don't think about yourself only as the person who is drafting the will. Think about yourself on the other side as well, where you're the heir. So as I'm chatting, think about your own family, your own dynamics, your own circumstances, where I might say something that resonates with you and you think, oh, I wonder if my parents have that in their will, because I'm probably going to be an heir in their will. Would my hubby or my partner have this in his will? Or if you've got older children who don't have children of their own and you might be their heir, do they have wills and do they have this in place? So think about all those different hats that you're wearing while we're having this conversation. And, and even if I'm speaking about minor children and your children are grown up already, and you think, well, okay, this part of it doesn't apply to me. It might apply because of grandchildren, or there's something that you hear today that could affect your sister who's got young children, or a friend. So just soak it all up, remember what you can, but basically we'll also have a recording of today's webinar, and then we'll share that with you as well. And if you don't hear from us, please do pop us an email on estates@stbb.co.za, and we'll share the recording, we'll share the live file, and any other brochures that you don't get access to on our website, okay? And hopefully what's going to come out of today's chat is for you to look at what you own in terms of assets, bank accounts, shares. Do you have anything offshore? What are you pretty much maybe going to own in future in the form of inheritance? Is there anything coming your way in terms of a divorce order or a land claim or anything at all that's not yet yours but might be yours? And that's something you've got to think about when you draft your will as well. And then as important as it is to look at the assets, we've got to also look at your expenses and your liabilities and your taxes. And I always tell people it's quite handy to look at your bank statement at the end of the month and see what's actually being paid for by you whilst you're alive. And so that's looking at your debit orders. Who do you pay money to? Who do you see to? You'll be surprised who your dependents are. So we're going to chat today about the various life stages, and I'm going to chat first about it could be younger women, but of course there could be any age woman who is unmarried. So adapt this to your own circumstances. But when I chat about the first life stage, it's people who are unmarried, they don't have children, they might never have children, or they'll still be family planning because they're still quite young. You might be thinking of marriage, and then we're going to chat very briefly about antenuptial contracts and the impact of the type of marriage that you choose to enter into and the impact on that on your death. And then the second stage is probably one of our bigger stages, which is, you're in a relationship, whether that's a marriage or something long term. You've got children. They might be minors under the age of 18, or you might have grown children. And how do we deal with all of that? And then besides your children who are your dependents at this stage, as you get older, your parents might also be your dependents. And you might also have siblings or other loved ones who are mentally incapacitated, who need to be specially looked at in their estate planning. You might have someone who is mentally incapacitated and can't manage any of their own affairs, and that person needs care. So what happens when you pass away, if you are taking care of them financially or physically or both? What happens if one of your heirs is you might have a sibling who is a drug addict or an alcoholic, and yet you want to take care of them as well? How do we go about that, and how do we structure that in the will? You might have a parent or a sibling who has dementia, or there's a fear that that you're seeing early signs of dementia, or if you're in the latest stage that we're going to deal with last, which is our older clients. What do we then look at in putting in place for your heirs, who might be your spouse, who, as I said, might have be showing signs of mental incapacity, might be quite ill, but you still want to leave something to that person, or that person needs to be cared for? What happens if you are the only person in South Africa and your children are all living overseas? What if you live overseas and you want to draft a will for your loved ones who are in South Africa or all over the world as well? And then we'll chat about life rights and retirement, and people who enter into relationships later in life, and all of those issues around blended families and cohabitation agreements and all sorts of wild and wonderful things. And let me tell you, my team and I at STBB, we see all sorts of things. So there's no judgment. So you can ask any questions. We're here to help. And every family is so different, but there are some similar threads. So we're going to run through some of those now. So, okay, so let's chat first to those of you who are unmarried, and you might not be in any relationship. You might be thinking of having kids one day, or you might be in the stage of the relationship where you're starting to think about formalizing that into marriage. And as I said, just adapt what I'm saying to your circumstances. You might not be married or thinking of getting married at all, but some of these things might resonate with you. So when you are unmarried, and I get this question so often where people say, why do I need a will? I don't have any children yet, or I don't have a partner. Why on earth do I need a will, Refqah? Because I can really just carry on, and surely things just get dealt with when I pass away. And the short answer to that is, as someone who deals with the consequences of people not having wills, is get your will sorted out, get it signed. It could be the most basic will because, according to you, you don't own much yet. But each and every one of us is leaving a financial footprint behind. So you might not have big assets in the form of maybe owning a property yet, but you certainly, I think most people by now have a bank account. So if you're employed, you have a bank account. If you are a stay-at-home wife, or not at that stage yet, but you might be at home looking after parents or unemployed, I'd hope that you have a bank account, but you might have some assets. You've got something. I mean, surely if you look around in your home, some of those things are yours. So as soon as you have a footprint of you own something, you own assets, you've got a bank account, and depending on where you are in your life, you might be a taxpayer as well. So when you die, you are going to leave some obligations and admin behind. And so it's important to have a document like a will, which can guide your loved ones as to what to do when you pass away. Even more important than sorting out your affairs, I feel that when I sit across from grieving families, that fear of the unknown, that worry, and that stress in not knowing what to do now that you've passed away, if you can help alleviate that distress in your family's lives by just having a will signed, and it can be straightforward, can be simple. Just make sure you've got a valid will and let your family know where that will is. Over the past month, I've been contacted by so many people who've lost loved ones and they didn't know where to start. They couldn't tell me where their sibling had a bank account, where their dad had any investments, was there life insurance. They didn't know anything, and it's okay to be private. But then if your privacy extends to your family not knowing where anything is, then at the very least, give them my details, for example, and say everything you need to know is with Refqah or with her firm, STBB. Just get in touch with these people if I pass away. That's good enough if you don't want your family members to know your ins and outs and your business. But it certainly does help if you can at least tell them that you do have a will, where it is, and if you do have that open relationship, start chatting to your families about what's actually in your will. So that's the first thing. And then if you are a young person thinking of getting married, or you've got children of your own who are thinking of getting married, it's really important to consider what the consequences are of that marriage down the line, because depending on the type of marriage and the consequences and the impact on your own assets or your estate, when you pass away, or sadly, if the marriage ends because of divorce, then that decision you're making now at this stage in your life is going to play a huge role. So when you opt to get married in South Africa and you've got the options of getting married in terms of South African law in or out of community or property, very quickly, because we only have time to touch on lots of points. In community or property means that from the minute you get married, your estate and your spouse's estate are one, and it's called the joint estate. So what does that mean? Very simply, if you get married and you have 1,000 rand and your husband has 2 million rand, together you own 2,001 rand, 1,000, 2,000,001 1,000 rand. So what that means is that whatever he owns, you own. Whatever he owes to any creditor, you owe. So it's very important that you understand that, because when people say to me, well, we're getting married and we're getting married in community of property, which I never recommend, by the way. We're getting married in community of property, and that's going to be okay because I'm going to be working and he's going to be working and we're going to build a life together and blah, blah, blah. And all of that's fabulous when things are fabulous and going well, right? And I know this is not a family law chat about marriages, but I just wanted to draw your attention to it because we're chatting about estate planning. And when we're dealing with young people, it's so important to get the necessary advice and find out what the consequences would be if you get married a certain way, because it's quite costly to change that down the line if you want to change from a marriage in community of property to out of community of property. So when someone passes away, many years, hopefully after they've gotten married, when the first person passes away, we don't only value the deceased person's estate, because there is no deceased person's estate without the partner. It's a joint estate. So what happens is, someone passed away the other day, and the wife was worth almost nothing. She'd been a stay-at-home mom, and she had a bank account with a nominal bank balance. But the husband had all the assets in his name. He had the house in his name, he had the investments in his name, and he had the cars in his name. And he was covering all of those costs. But when she passed away, what happened? The value is in the joint estate. So combined, she might have been worth almost nothing, but their combined value is actually 15 million rand. So she does have an estate, because half of that 15 million rand, the 7.5 million, is her estate. So we've got to deal with that. So it's important when you're married in community of property that you definitely have a will, because if you don't, intestate succession kicks in, and your spouse and children, and if you don't have children, then your spouse only would be entitled to inherit from you. And imagine, you're that person who owns all of that. And now I'm saying, well, actually, your spouse has just passed away, but you didn't leave a will, or not a valid will, and actually the assets that you think are yours, that you think you're just automatically inheriting from her, then by default doesn't apply because of the value of your estate. And so you and your children are actually inheriting her half of your assets. So it's very, very important to understand that when you're married in community of property. What I normally advocate is married out of community of property. And there are two types. So you're married out of community of property, and you've then got an antenuptial contract. And the antenuptial contract gets signed before you get married. And that antenuptial contract can take one or two forms. You can either have an antenuptial contract, which is what I call very straightforward. It excludes accrual. That means what's yours is yours, what's mine is mine, and that's it. I own my own assets. When I die, I can do with those assets what I want to. I can leave it to whoever I want to. My debts are mine, my liabilities. Unless you're co-owning a property with your spouse and you're married out of community of property, you will own all your own assets. So if you co-own the house, you own half the house. So in your will, you can deal with half the house, okay? So, and if you're married out of community of property, but you chose the second option, which is with accrual very simply is I'm going to say it's simple because it's not simple, is a split of the difference in value of the two estates. So let me give you an example to make it clear. Again, if you're coming into the marriage with nothing, and if he comes into the marriage, also, let's say you're both starting out, you're young, you're both worth exactly the same value, and then we'd start the antenuptial contract with accrual, the starting values as you go into your marriage. Let's say that's null. And when you, on the first dying, so let's say your husband dies first, and he is worth more than you. Let's say by the time he passes away, you're worth 1 million rand and he's worth 2 million rand. The difference between the two estates is 1 million rand. So half of that difference is 500,000. And the bigger estate, his estate, would have to pay the 500,000 to you on his death, either in assets or in cash. And what that means is that when we're chatting and when you start thinking in estate planning around what you own and what you owe, don't forget, if you're married in community of property, that if you are worth more than your spouse will have a claim against you, an automatic claim that has to be settled either in assets or in cash on the death of the first dying of you. So if you die first and you're worth more, then your estate has a creditor in your husband. And so when you're planning your will, think about that. And when you're thinking about all your expenses and you think, okay, I need to have cash or life insurance for my taxes and my transfer costs and my estate admin costs and if I pass away, I pay the kids' school fees, so I need to make provision for all of that. And what if they go to varsity? And so when you start planning with us, and I see that you're married out of community of property, we also have to take the accrual into account because there's a potential claim either against you if your estate's the bigger estate or in your favor. So if you pass away first and your estate is worth less than your husband's, then your husband who's still alive has to pay your estate. Okay. Of course, if your husband's your sole heir, it kind of gets set off against the other because he's going to inherit everything anyway. And then the claim, he doesn't have to pay into the estate because he's going to be inheriting, but that gets sorted out when we do the estate administration. But so just keep that in mind. Accrual is very important. And in your accrual, you can, of course, exclude certain things and say, well, for purposes of accrual, we're not going to take into account inheritance, anything I'm going to inherit from, whoever I inherit from. There might be anything else you want to exclude as well. So think about that, young people or older people, when you are thinking of getting married. Come and have a chat with one of our colleagues in family law or ourselves just around antenuptial contracts. And then if you are unmarried and you don't have children, um, and then think about who your heirs are. So often for young people, when they draw up wills, their heirs are their parents or their parents and their siblings. So think about that and think about how practical it is to leave something to a parent, and always make sure you've got an alternate beneficiary or heir mentioned in your will as well, in anyone's will, because that person could pass away and you forgot to update your will. So you want to have an alternate beneficiary. So if you, as an unmarried or person or someone who doesn't have children, you think, okay, my parents are going to be my heirs, but what if my parents pass away before me or with me? Then maybe my siblings, or if I don't have siblings, who am I leaving it to? And start thinking about cousins, bestie, all those people. And so when you or any of you are thinking of putting an older person like a parent as your heir, then do consider the clauses that you need to put in place in the event of that person being mentally incapacitated, in the form of dementia or Alzheimer's, or anything else that debilitates their mental capacity to manage their own affairs and in turn to accept any inheritance or to manage a property. And this doesn't just apply to this first life stage, can apply to anybody, of course, and certainly it's going to apply when we deal with older clients and their wills and they're leaving things to a spouse who's also at an age already. But I'm going to chat about it now because it comes up so often where people ask me about what happens if I leave something to someone who's got dementia, or I really want to take care of my sister and she has some mental incapacity and she needs care, or I'd like to leave something to my brother, but he's been in and out of rehab. He's got all sorts of issues. And how do I leave things for him? Or what happens if you've got a sibling like that with any type of incapacity, and you know that your parents' will says that the house is going to be left to you and that brother. So you're going to be tied to him and you can't do anything about it because, maybe he's an alcoholic and like, oh my gosh, how am I going to co-own a property with this guy? I can't even find him half the time. So all very real and very serious, and they have serious consequences. Because if you leave any inheritance to anyone who's mentally incapable of managing their own affairs, one thing's going to happen. That person is going to inherit, okay, because the will says so. Or if the person didn't leave a valid will in terms of intestate succession, if that is the person that's supposed to inherit in terms of South African law, then that's the person that's going to co-own that house with you. And that's not what you ultimately want. So what I recommend is that think about putting in clauses in your will where you're leaving that person's inheritance to them, but in a trust for their benefit. What happens by the time you pass away is that we look at who the beneficiaries are, that are inheriting in terms of a trust. And when we get to the second stage in your life, when we're dealing with minor children and their inheritance goes into a testamentary trust, we'll touch on it as well. But if any heir is leaving anything to anyone in trust, what happens is each person gets their own trust. It's not one trust that has, different beneficiaries. So if you leave something to an heir and that person might be an adult, so it's not a minor who might then inherit from that trust when that person, that minor, reaches a certain age. For example, if you say a minor, in your will you say this minor will be entitled to the inheritance when she turns 18 or 21 or 25 or 30 or whatever it is, you're leaving inheritance to someone who's already an adult. It might be a parent who's got dementia. It might be, as I said, a sibling who's a drug addict. So you're leaving it to an adult. So it's very important that you stipulate who the alternate beneficiary is going to be when that person passes away, because it's very different to a testamentary trust for a minor child, because that minor is going to then inherit when she reaches a majority. But so think about that. If I leave assets to my dad, and I think, okay, but what happens if I pass away before dad, and dad then develops his dementia gets worse, and he won't be able to manage this. So I would leave his inheritance for his benefit, whether it's assets or cash, preferably cash, and that's left in a special trust for my dad's benefit for his lifetime. And then you've got to nominate trustees as you would with any testamentary trust. And you nominate a trustee, maybe a sister or STBB, for example. I'm a trustee on so many trusts. And we then manage that trust. And what happens is we manage the funds or the assets so that it's for full benefit of dad's debit orders get settled, if there's medical aid, if he's in a care facility, that gets paid monthly as well. If there's someone living with dad in his home and looking after him, we just make sure we pay that person monthly for the groceries and whatever that person needs. And then it's very important in your will that you then nominate someone as an alternate beneficiary so that when dad passes away, anything left in that trust, whether it's assets or cash or both, that's then passed on to the next heir. So you might say, okay, when dad passes away, I'd like that left to my sister or my sister's children or whatever. So, and you've got to just name them. So that's a really simple and easy mechanism, which I really can't stress enough, because the alternate is, imagine now you've got a will where you leave, or your parents have a will which says, and you and your brother are going to inherit from your dad, and your dad's will says that he leaves everything to you and your brother, but your brother's a drug addict and he's not mentally capable of making decisions. He's erratic. You can't find him half the time. But now you've inherited a property together. So what will happen is the transfer will happen, and you would have to take transfer, and he would have to take transfer of his half share of the property, but he can't sign documentation. So depending on the stage of anyone's mental incapacity, they might have a lucid moment, a good moment when they can actually sign and they completely understand what's going on. But then other costs can kick in, because if that person is not capable of understanding the documentation that they need to sign and accepting inheritance, that person would need to be placed under curatorship. And we do attend to curatorships for so many people, either elderly parents or people who are not able to take care of themselves. And that curatorship application, unfortunately, costs money, because it goes to speaks to your capacity, and so it goes to the High Court. And so you're easily looking at, 70, 80,000 Rand in respect of having a curator appointed to manage your brother's assets. And then I step into your brother's shoes as curator. And so then you are co-owning a property with your brother who's under curatorship. And so you and I basically are the owners of that property, as long as I'm his curator for his lifetime. And decisions get made between yourself and myself as his curator. And if there's any cash, then that gets managed, for his benefit as well. So it just starts adding up, and it gets, as I said, just you can really reduce the stress in a family if you just have a good will. So I can't recommend special trusts enough. And then, so leave the breadcrumbs is what I'm saying. Okay, so leave the breadcrumbs. Make sure that you've got sufficient funds there for an heir. Make sure that you've got a paper trail and the breadcrumbs for your family as to where your will is, what it's going to look like when you pass away. When you're young, explain to your parents that if something happens to you and if you're paying their bills, just reassure them that things are in place. So if I pass away, this is who you get hold of, and then that's just something to think about as well. Let's jump forward quickly to our next stage, which is when you are a parent. So now you've gotten married, you've signed the antenuptial, you've listened to Refqah, you got married out of community or property, you've got the antenuptial contract in the safe. You never need to look at that. It really only kicks in on death or divorce. And now you've started a family. So you definitely need a will when it comes to your minor children, and they are minors until they reach the age of 18. So in your will, think practically, who are those guardians? And that's going to change, right? Because your relationships with people change, your children's relationship with people change as well. And you'll see who your kids start gravitating towards, and, got sort of shared like-minded values. And who do you think is going to, eeny, meeny, miny, mo, who's going to be prepared to move into your house to look after your kids if you both pass away. It's important to understand that if you are separated from or divorced from the other parent of your child, so I'm chatting to mainly women, so I'm going to say if the father of your child is not in your life, just remember that that person will always be the natural guardian. Natural because obviously he's a biological father. So the natural guardian of your child, either the biological or adoptive father of your child, is the natural guardian. And something that I really want to stress when it comes to minor children is when we're dealing with an estate, some things fall outside the estate administration process. And that would be when you've got life insurance and any policy products where you have a named beneficiary. So when you've got life insurance and then you've nominated your daughter, and let's say you are a single parent and you've nominated your only child, you've got a daughter, she's 6 years old, you've nominated her as the beneficiary of your life insurance policy. But then you also came to me and you've got a will. And in terms of your will, you've set up everything. You've nominated an alternate guardian. If her dad passes away, you've nominated your sister and your best friend maybe as guardians. You've then set up a testamentary trust in your will, which we'll chat about now as well. And that's for the benefit of your daughter. But then what happens if your will covers your assets and your liabilities? That, think of a bubble. So all of that's part of your estate. But sitting outside the will and the estate are your life insurance policies and any other products that I said with a named beneficiary, because that's going to be paid directly to the heir. So that gets paid directly to the heir. So that's going to be paid directly into that little girl's bank account unless the trustees of that life insurance fund consider it wise to and prudent to rather pay something monthly into her account. Okay. But who's got access to her account? You've set up a will where she's got a testamentary trust for her assets. She's going to inherit the house, she's going to inherit all sorts of other cash. But the life insurance falls outside that protection. So her dad, who you have no relationship with, is her natural guardian, and he's going to have access to that bank account with the 3 million rand life insurance. So I would ask you to come and chat to us about your estate planning and also chat to your financial advisor, because people obviously understandably want to have their life insurance outside of their estate to reduce estate administration costs, and that's absolutely fine. But think about it, because depending on the circumstances, and who would be looking after that minor child, you might rather want to then nominate as beneficiary. You could have some of it going to your daughter's account, but you could also have, depending on who you trust, right, who's going to be looking after her and her bank account, if you get along with the father of your child. But if there's an issue around the potential issues around the guardian, then think about that beneficiary of your life insurance rather being the testamentary trust to be formed in my will dated so and so. Because then when you pass away, the life insurance company will then look at it and see, okay, there's a will, say with STBB, and in terms of that will, the executors will eventually form a trust. And when that trust is formed, they will transfer that money into the trust, and the trustees that you nominated in your will be entrusted to look after that money for your daughter. Okay, so there's so many scenarios around life insurance, and I know we don't have time for it, but think about that. Look at your life insurance policies and any other policies where you've got named beneficiaries, and just check and make sure that it's actually practical and not just around minor children. Things that I see where, so let's say you've got a will where you've left, you think, okay, your spouse, you're not sure, oh, this man's definitely going to get married when I die, so I'm going to leave the house to my kids, and I'm going to leave the, certain assets to different people. But then you leave your life insurance policy to a different person. So your life insurance policy beneficiary is your husband, and your husband gets paid out, but he's not getting the house. So where's the motivation? Why would he want to pay off the bond with the life insurance money if he's not inheriting that property? So think about that as well. And you can have maybe numerous beneficiaries depending on what you need that money for. It's like, well, okay, someone that's going to have to go to settle a bond, so let me leave that amount to that person who's going to be inheriting the house, So we've got to chat about that. So when you come and do your estate planning, you also bring along your policy schedule and let us know who the beneficiaries are. So check all of those things holistically. It's not just the will. What does that mean? Where's the cash coming from to enact all these things I want in my will, and who's going to get that cash, and would they actually use that life insurance to settle all the things that I want them to settle? Because there's no legal obligation on anyone who's inheriting in terms of life insurance to actually pay that in terms of your debt, because you've actually said that all of that money is going to that person. Okay, so think about that sort of thing. I want to quickly jump onto property. Think about your primary residence. That's the home that you live in. Think practically. Put yourself in your heirs' shoes. Would you want to inherit a property with your siblings or not? Think about what you're leaving people and the obligation. So people leave a house to 3 children, but then the youngest is allowed to live there. So you're not actually leaving inheritance. You're just making them a babysitter for someone who gets to live in the house. And what does that mean? They get to own it, but they don't get to enjoy it because their sister, who is only a year younger than them, can actually live in that house forever. So you've got to think practically, what does that mean for the other person? I'm saying that you get to live here. Your sister gets to live in the house, but you don't, and you can't practically all live in the house. So and there's so many different configurations of homes. Some people have got separate entrances, and look at your property. Look at whether you can subdivide it into 2 or 3 if you're going to leave it to 2 or 3 people. Can you sectionalize it? Meaning, can your house be converted into a block of flats? Do you have a double story where you can leave one floor, to one person and the top floor to someone else? Your flats could be next to each other. If you've got one house and someone you've built on an extra dwelling, that could be unit section 1 and section 2. Are there separate driveways? Where are the costs coming from to cover all of those sort of things? So think about those configurations. Or do you rather want to say, you know what, I'm going to give one of my kids first option to buy this house at market value, and the others can get the cash? Or if you've got 3 children and you're thinking, okay, I'd really like X to own the property, but then Y and Z can maybe get something else. And it's often difficult, right? Because the house is the most expensive asset that you're leaving. So maybe think of taking out life insurance to that value, to say, okay, I'm leaving a 2 million rand house, let me leave a 2 million rand policy, to the other child. So you can rather think of cash versus assets, but think about it. And when it comes to property, there's a whole conversation that needs to be had. Do you also co-own property? What does that mean? You co-own property with somebody else. Do you co-own a property with a sibling, with a business partner, with friends? Did you go into it together and you own a third? You're not going to want to leave your third of the property, to your husband and children. Then they're going to have to co-own it with your two besties. Rather have a co-ownership agreement in place while you're alive if you co-own any property, as to what's supposed to happen when one of you passes away. When I pass away, it could say, well, the others have to buy out my share at market value and pay that money to my estate. And then the money gets split between the family. Or the three of you bought the property for a reason, because as friends, you couldn't afford it together and you're enjoying the rental income. And then maybe there's agreement to say, okay, when one of us passes away, the other two have first option to buy out my share and pay it into the estate. And if we can't afford to do that, we've got to decide within 60 days of my death, then we agree that the property must be sold and we all just take a third after expenses. So think about that. And do you own a business? Are you a shareholder in a company? Are you a member of a CC? Are you a sole proprietor? So are you a dentist, a doctor, a physio, a nail technician? Do you have your own business, and are you the business? And will that business then die when you die? Or can it carry on? If it can carry on, what have you put in place? What are your obligations to your employees? Do you have employment contracts? Have a basic employment contract so that everyone understands what happens. The worst is when a single practitioner passes away, and then there's a bit of panic, and you need to have liquidity in place so that salaries can still be settled. Your tax still needs to be done. In each of these stages of your life, you need to make sure that you've got liquidity. Where's the money to cover the taxes? Where's the money to pay someone's salary? So your business will be valued. Is there goodwill? Is there a client book that can be sold? Is there stock in that dental practice and that fabulous chair? Can all of this be sold? You might have a preference, and you might put in your will, well, if my practice is sold, I'd like, it to be offered to so-and-so. There might be a competitor or someone that you really admire in your field that you'd like to give them the option if they'd like to buy it. Leave the breadcrumbs. Let us and your family know what to do. You know who your colleagues are. We might not know who the colleagues are. And so leave the breadcrumbs when you've got a business. Make sure that in a partnership or in your company, do you have buy and sell agreements? What happens when one shareholder passes away? Does the business have life insurance on your life so that when you pass away, some cash is going to come into the business in the form of life insurance into that business, and then the business or the partners would be the beneficiaries of that life insurance policy in that case, so that can come in, so that there's some cash liquidity. So think about those sort of things, and in all of your life stages, start thinking about the insurance behind it. Whether, even if you don't believe in, there's some people that don't believe in taking out life insurance, that's absolutely fine. But then you're going to have sufficient cash to cover all the expenses. You're leaving an asset, or you're leaving a house, it has to be transferred. Where are the transfer costs for that? You're leaving your children in the care of someone that you're nominating as guardian. Where's the money for that to happen? A trust is going to be set up. Where's the money for the trust to actually carry on running all the things that you want to run? Okay, so start looking at that. Look at if you've got sufficient life cover for not only your liabilities, but for the consequences of what you've left behind in terms of trusts. And then before we open it up, I want to, of course, chat to our older clients. And people are buying in retirement homes, and they're buying in life right schemes. And a life right, very quickly, is very different to conventional property ownership. Life right is when you're buying the right to live in a property for the rest of your life, though that property is owned by, say, the developer of that scheme. So you don't have conventional ownership. It's not a right that you can transfer to anyone. So it's very important to understand, and to understand if you've got parents who are in life rights, it's nothing that you can look forward to inheriting, but not in terms of the property, certainly. But what will happen is, if there's a life right agreement by, let's say, both of your parents, it applies to both of them. So on the death of the first parent passes away, the life right just carries on. So nothing changes in the form of the life right asset, because your mom or your dad's partner is still alive and living in that property. So the life right carries on, and that person enjoys the right to live there. You're paying monthly levies or whatever you're paying. On the death of the second dying, so on the death of your mom or the partner, only then does the life right agreement come to an end, in terms of which the developer then sells that right to the next couple, and the estate of the second dying will get back the original purchase price plus a percentage of the profit from the transfer, the proceeds of sale, depending on whatever was agreed to and whatever's in the life right agreement. But it's important to understand, when you buy into life rights as an older person, if you're the one paying for it and you die first, your girlfriend or your second wife that estate is going to enjoy the benefits. So you've got to make sure that there are agreements in place and so on as well. Okay. So life rights are very tricky. And when you're older, certainly it's very important to have a cohabitation agreement, and a will, because now it's going to be blended families, and you're going to have your children, his children, your assets, his assets. There might be very different financial circumstances involved, and there's going to be lots of expectation, and there might be animosity. And so in terms of the family dynamics, it's very important to have a will, let your family know what's going on, and also look at what the expectations are of your family. And in all of those stages, whether you are just starting out and just newly married, or in an early relationship as a young person, or if you are, deep in the trenches with your spouse and lots of children and all of that in that middle stage of life, or you've then gotten divorced and now you're in a new relationship, or you're an older person, either still with your original spouse, or you've now gone to a second wife, or you're not married, but you've got a relationship. There's always a potential for another claim, and that claim is maintenance. And so personal maintenance by that partner. So keep that in mind as well when you're sitting there working out what the expenses would be after you pass away. Even if you leave inheritance to a partner, if that person feels that it's insufficient for their personal maintenance, and they can prove that you've taken care of them and paid for things during your relationship, there might be a maintenance claim against your estate by that partner. They don't have to be married to you. They can show that you took care of things. So I'm not saying don't take care of things, because there'll be a claim, but that's also something to think about and to come and chat to a professional about when you are when you're planning, when you're drafting your will. Sometimes people say, no, but it's absolutely fine. We're both at the twilight stages of our lives, and we all understand, we've all got our own assets, and our kids understand, and so on. But you'll be surprised at the maintenance claims that we do see. So do keep that in mind as well. So think about your assets. What do you own? What do you owe? And what are you putting in place in your will? And do you have the cash set aside, or do you feel that your heirs are financially by the means to be able to implement all of these things if you don't have the cash? And who do you need to look after or who needs to be looked after you pass away? Potentially parents, um, young children, even your old children still need looking after sometimes, anyone with special needs or mental incapacity. And you need to put things in place for each person. And your family needs to understand, even if you don't want to tell them how much you own and where your shares are and that you've got crypto and all of that stuff, that's okay. But at the very least, let them know, when I die, and if Granny's still with us, then this is the plan. And, Uncle so-and-so, who we look after, who's got Alzheimer's, this is the plan when he dies. It's very important for your family to understand what happens. And it's also important, as I said, for them to know who to come to. So if it's with us, fabulous, you've made a great decision. If not, let your family know where your will is, who it's with, and do contact us at Estates at STBB for that live file. I think we've got a minute or two to whip through some questions. Thank you for listening. I hope you all enjoyed it. And there's always so much to chat about. So let me just see what people are asking. So someone has asked, so what if you are married according to Muslim rights? Is the consequences like a marriage of out of community property without accrual? So when you're married in terms of Muslim rights, very quickly, you're not married in terms of South African law. Of course, there are all sorts of changes coming in all the time, but a Muslim marriage has the same consequences as a marriage out of community of property, which means that what's mine is mine, what's his is his. Um, so that's the consequences of the marriage, which means that you can do with your assets what you want to. And if you're then having a Sharia compliant will, we can draw that up for you as well. And then, of course, you'll each inherit in your Islamic shares. In terms of your will, but you've got to put that in a will because we don't live in a Muslim country. So if you pass away without a will, then intestate succession kicks in, which has very different shares to Islamic law. But yes, what's yours is yours and what's his is his. So generally, when we draw up antenuptial contracts for Muslim couples who want to get married by both South African law and in terms of Sharia, then we draw up an antenuptial contract without accrual because accrual isn't included in Islamic law. Okay. Lovely. I don't see any other questions. So, hope you enjoyed that. And please do get hold of us at estates@stbb.co.za. And a will is something that you do update at your different stages in your life. So do look at doing that as well and get in touch. Thanks, everybody, and visit our website and do keep an eye out on our socials for any other webinars and any talks. Keep well. Bye.